Since December last year, the SEC vs. Ripple lawsuit has been going on, and both the plaintiffs and defendants have been attempting to convince the court of their side of the story. What do you think the end to this will be? And when will this case be solved? Will Ripple win? Stay tuned to find it all out. But first, we are giving away $25 at the end of the month to one random subscriber to start on their XRP journey. All you need to do is like the video, subscribe, and comment your thoughts on XRP in the comments section. Welcome XRP Army, let's grow the XRP Lab community by pressing the like button and subscribe. Crypto legal specialist and Ripple supporter Jeremy Hogan is hinting at when the San Francisco-based payment company's lawsuit with the US Securities and Exchange Commission (SEC) may end. Hogan states that a settlement between Ripple and the SEC is expected to occur after the discovery phase, which is the pre-trial phase of a lawsuit, where both parties present essential information and evidence. Hogan estimates when the discovery phase is expected to conclude and thus when a settlement between Ripple and the SEC could be attained. There will be no settlement happening until after the close of discovery. Could it settle before then? So any compensation is supposed to be after at least the close of fact-finding. And if it doesn't settle, then Judge Torres will decide two main arguments as summary judgment. Looking at the summary judgment rule briefly, you can notice that motions for summary judgments must be registered within 30 days of the close of discovery. Hogan foretells a series of back-and-forth responses to the motion for summary judgments if the case is not settled, prolonging the case beyond November and into 2022. The lawyer states that the SEC is expected in no rush to end the lawsuit, noting that the top regulator was just successfully given a 2-month extension to the discovery process. There isn't any reason why the SEC is going to be in any hurry for this case. The more time goes by, the better the SEC's settlement position because the more pain for Ripple. It's a prevalent tactic. This past week, Ripple marked a small victory in its fight with the SEC, in which Judge Sarah Netburn dismissed the SEC access to documents about Ripple's past lobbying efforts. The SEC claims that the defendants bear the burden of proving exceptional circumstances justifying the deposition, and stated that Ripple Labs and its co-founders could not meet this high burden. According to the motion, the defendants want Mr. Hinman's testimony on the SEC's internal views and policy decision-making. To dispute the deposition, the regulator stated that Mr. Hinman was of critical attention to the SEC's operations, has no first-hand knowledge of the facts underlying this action, and defendants cannot meet the load of exceptional circumstances. Who is William H. Hinman? Calling the former SEC Director of Corporate Finance to the stand may be part of Ripple's move to shift the lawsuit against the SEC. Mr. Hinman was the one that ruled that Bitcoin and Ethereum are not securities. However, the latter debuted in an initial coin offering (ICO) in 2014. With XRP, they said its status had not been determined. When Ripple demanded the internal documentation to demonstrate how and why the SEC made its decisions, the regulator stated that nothing Clayton and Hinman and any SEC official told about Bitcoin or Ether was an official determination on whether they're securities. There might be a conflict of interest in action, as Hinman left the SEC and returned to Simpson Thacher, giving him a $1.6 million annual pension. The law firm is related to the Ethereum Enterprise Alliance. It seems that XRP doesn't have to be a security to become sued by the SEC. SEC Commissioner Hester Pierce, also called Crypto Mom, has recently stated that the SEC should focus more on regulatory clarity and less on enforcement at present. Thinking about a crypto asset as a security is being sold as part of an investment contract. It doesn't mean that the asset itself necessarily has to be a security. It indicates that it was being sold as a security. This could relate to XRP as well. The SEC complaint filed on 22 December 2020 doesn't seem to state that broader view. The SEC first announced that it had filed an action against Ripple Labs Inc. and two of its executives, who are also important security holders, alleging that they raised over $1.3 billion through an unregistered ongoing digital asset securities offering. Throughout the lawsuit, the regulator has declared that Ripple's XRP is safe due to its centralized nature, and so it falls under its regulatory scope. Ripple states that it never held an ICO, nor its digital asset can be described as security, since its utility is proven every day across the globe as it's done for cross-border payments. Ripple wants to question ex-SEC official. According to lawyer James Filan, Ripple's deposition request aims to bring an ex-SEC member to court. He writes, "This means that Ripple wants to question a former SEC official under oath deposition." Filan added that the community does not know who the former SEC official is yet. However, several high-profile members have left the SEC in recent months and all are potential candidates. One candidate is former SEC Chairman Jay Clayton, liable for initiating the case against Ripple last December. Given his involvement in the case, he is a reasonable candidate. Other possibilities include William Hinman, Sagar Teotia, and Stephanie Avakian. Each individual left the SEC in the last several months. However, each has had insignificant involvement in the case, and as such, they are less likely subjects. Meanwhile, the SEC is striving to quash Ripple's request. Filan noted that the SEC objects to the deposition. He records that Ripple and the SEC could not work out their differences and wants Magistrate Judge Sarah Nedburn to determine what will happen. It's not clear what Ripple tries to accomplish by having a former SEC member testify in court. However, Ripple earlier criticized the SEC for launching its legal case during the Trump administration and the Biden administration transition. Ripple CEO Brad Garlinghouse stated in April, "Jay Clayton, the day before he resigned from office, brought this lawsuit against Ripple and against him personally. To do that the day before he leaves his position, he thinks it was misguided. If the former SEC member does not provide testimony, Ripple's charges around the changeover seem reasonable." The SEC initially launched its lawsuit against Ripple in December 2020, when it declared that its XRP token sales constituted an unregistered securities offering. Earlier this month, Ripple claimed that the SEC did not give it fair notice before the lawsuit. Until recently, the court had a host of motions pending on its table. However, the judge finally decided to grant the regulatory agency additional time for discovery, despite Ripple's opposition. With this ruling, the case is unquestionably set to be prolonged further, and now the discovery phase will resolve itself only by 16th October. The court ruling has undoubtedly hindered the momentum that the defendants had until a few weeks ago. Commenting on similar lines, famous attorney Jeremy Hogan said, "The odds of a settlement at this stage cannot be wiped off thoroughly. However, it should be noted that a settlement would only happen after the close of the fact discovery, the deadline for which has already been stretched." Additionally, with the change of administration in the US, people from the XRP community believe that the new chairman of the SEC, Gary Gensler, would personally get connected in the case. According to Hogan, that's not going to occur. What's more, the motions for the summary judgment must be registered within 30 days of the close of discovery. The judge pushing the discovery back 60 days does change the time frames. The attorney, however, considers that 60 days is just the blink of an eye to the rock. Even though it isn't clear who has the upper hand, it wouldn't be wrong to say that the pendulum is swinging in favor of the blockchain corporation, at least for the time being. However, it should be noted that even if Ripple wins the fair notice motion, that does not ensure a victory at trial. Hines clarified the situation by saying, "Winning on this motion does not mean the defense will win on trial. It's just that it can be presented at trial. Winning this is not an indicator that the judge will side with this defense regarding the disposition of the case in issue." The information provided in this video does not constitute investment advice, financial advice, trading advice, or any other sort of advice, and you should not treat any of the content as such. The content in this video is for educational purposes only, and hence should not be considered as financial advice. Do conduct your due diligence and consult your financial advisor before making any investment decisions. Do you invest in XRP? Let us know in the comments below. We've got 2 more videos waiting for you on the end screen to check out. Make sure to subscribe and give us a thumbs up. Thank you so much for watching. See you in the next video, my friend.